Hi everyone, I'm Jenna from the Miller Elder Law Firm and just wanted to take a minute today and discuss some of the documents that you're going to be signing and a little explanation as to what those documents are. Let's talk about the Durable Power of Attorney, or DPOA. That document deals with everything in your financial house. So appointing an individual or your agent to make decisions as they pertain to your finances and to some of your property. You'll also note that when you go through the document, there's probably about 25 to 30 different paragraphs, and maybe half of those paragraphs have little spaces for you to initial. And you're going to affix first, middle, and last initial on each of the spaces provided to the left of those numbered paragraphs. And the reason that we're asking you to do that today is because in 2011, the law changed such that those are what the legislature determined to be the superpowers, or the most important things that you need to double down on to ensure that you're going to grant that authority to your agent. So that's why we're asking you to specifically enumerate those paragraphs. But everything here does not wait till incapacity. So the moment that you're signing this document, you are empowering your agent to help when and if you need that. Like I said, it doesn't wait for incapacity. It does take effect immediately upon signing. But remember, the people that you're appointing are your fiduciaries. So they cannot act in anything that is different other than your expressed wishes, your desires, your best interest. And so hopefully that gives you a little bit of context when you're signing your Durable Power of Attorney today.
Hi, I'm Shannon. We're going to talk today about pre-need consents against exploitation. The pre-need consent against exploitation, you're going to see there's actually two places for you to sign. The first is saying, hey, if I start giving my money away to a scammer or an exploiter, these are the people who I have identified that I want to be able to freeze my assets. The second page is a consent against exploitation, and that's what gets filed with the court to freeze your assets down. So if you start to give your money away because you're exploitable, like your brain is changing and now you don't realize and you've attached to a delusion, you sign these documents that authorizes these people to go to court and freeze your assets down. Pre-need consent against exploitation.
The healthcare surrogate is completely different than a durable power of attorney or a pre-need consent against exploitation, or frankly, an enhanced life estate deed. Those three documents are dealing with financial or property matters. So now we've shifted gears and we're talking about all things in your healthcare house. The designation of healthcare surrogate is going to be a document that empowers and enables your named trusted agents to obtain medical information, to make medical decisions, and whether you're unable to speak for yourself or you're just wanting an extra set of ears and eyes and support, either one of those things can be true. There are going to be 3 spots to initial, first, middle, last initial on those spots, but there's also one additional spot, and it's going to be in the box at the bottom with a bunch of bold capital letters. And in that box, the initialing space is for the healthcare surrogate to take effect immediately. We, generally speaking, tell our clients that if they're comfortable with their agents and they trust their agents, that this box is really something that is a good idea for them to sign, because you want people to be able to support you, and you don't necessarily want to give them a hurdle before they're able to act. So initialing in that little box allows the healthcare surrogate's decision-making authority to support you immediately. But some people also are a little wary of giving that authority right away. But if you read a little bit further down that paragraph, it also says that so long as you, the principal, has the capacity to make your own informed decisions, that the principal's decisions supersede those of the healthcare surrogate. So we encourage you to make an informed decision, to sign that box, but do understand that so long as you have the capacity, your decisions and your decision-making ability supersedes that of your surrogate. Let's talk about the living will. So the living will, although it is a standalone document, it is actually a tool under the umbrella of a healthcare surrogate. So your healthcare surrogate is going to go through and be the one obtaining medical information, making medical decisions on a day-to-day basis. Now, the living will, you're going to appoint the same people. So what's in your living will in terms of your agents should be the exact same as the agents appointed in your healthcare surrogate. In the living will, it has a much more narrow application. It only applies in 3 very specific circumstances: an end-stage condition, a terminal condition, or a persistent vegetative state. And in those 3 categories, the living will can say many things, but more often than not, they say at a very high level, it's much more detailed than that, and you can go ahead and read it for yourself. But basically, in those 3 specific circumstances, I wish that my life not be artificially prolonged in any way. And you can read further as to specifically what is included or not included when you're signing this document. Now, conversely, in consultation with your attorney and how this document has been drafted, the living will could also say the complete opposite, which could be take all life-saving measures. So this is a very personal document. It deals with end-of-life decision-making. And in my opinion, it is a gift for your agents so that they are not left in one of these very difficult circumstances, making these even harder decisions about your life. I encourage you to read it thoroughly and make sure it matches your wishes, and allow your healthcare surrogates to have this tool if and when they ever needed it.
The Enhanced Life Estate Deed is unique to Florida. This deed is like a pay-on-death deed. It allows you to transfer property upon your death to the people that you've named on that deed. So with an Enhanced Life Estate Deed, also known as a ladybird deed, that deed conveys property upon your death, but not before you die. So you still retain all the rights of ownership. That means you can sell the property. You can retitle the property into your name and then convey it to somebody else. So if, say, for example, you sign this deed today, passing this property to your 2 daughters, if one of your daughters dies, you may want to retitle the property into your own name and then do a new Enhanced Life Estate Deed conveying the property to someone else. When you die, this property springs into the hands of the people that you've named on that deed. All they have to do is go to the courthouse, record your death certificate, then they can sell the property the next day. It allows you to avoid the process of probate. You get a stepped-up basis for capital gains taxes. There are all kinds of benefits to the Enhanced Life Estate Deed, and it does need to be notarized. If you have a spouse, you will retain all the rights of ownership even when the spouse is still living and you may have died. So they still retain all the rights of ownership until the death of the second spouse, the Enhanced Life Estate Deed.
Now that you've signed all your documents and you have your full estate planning package, we typically try to draft these documents for longevity. We don't want you having to make changes year after year after year. However, you have the ability to do so. So if at any point from now until the next life event or the next thing that pops into your mind, you are absolutely at liberty to make changes to your estate plan in consultation with your attorney. You also, just a matter of course, even if you haven't had huge life events occur and you think that your estate plan is generally still in good order, we recommend that you do take a little inventory of your estate plan every 3 to 5 years. And we are more than happy to look over those estate plans and give you some advice or some insight as to if changes are needed, and typically we will look over them at no cost. Please be empowered to make changes on your documents if you see fit, and certainly don't hesitate to reach out to us if you would like a second set of eyes.